Today we're going to talk about children inheriting in probate. My name is Gregory Singleton. I'm an estate planning and probate attorney living in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, this video is just for educational purposes only. It is not legal advice. And second, we are going to be talking about Minnesota statutory law. A lot of the concepts may be similar to what happens in other jurisdictions, but I think especially today, you're definitely going to want to talk to an attorney in your jurisdiction if you have specific questions about your situation. So the topic is children and inheriting in probate, and we're going to break this down into three parts. First of all is we're going to talk about the definition of a child. Second of all, we're going to do some hypotheticals of whether someone is a child or not. And third, we're going to say, why does it matter? So the definition of a child is, well, we look to the statutes first to see if there's anything. And luckily or unluckily, there is a definition of a child in the Minnesota statutes at 524.1-201(6). And it says, a child includes any individual entitled to take as a child under law by intestate succession from the parent whose relationship is involved, and excludes any person who is a stepchild, a foster child, a grandchild, or any more remote descendant. So it's great we have a definition. The problem is the definition defines being a child by saying it's a child. It's not great, and it also creates a lot of gray area out there. The main points as to whether someone is a child comes down to whether there's a birth certificate or adoption papers, or B, whether there's a parent-child relationship in that the child was dependent or being raised by the parent or should have been raised by the parent. Let's look at some hypotheticals and see how this plays out. The first is going to be gestation. What if a grandfather in his will says, I give my entire estate to my grandchildren in equal shares? When the grandfather dies, his daughter is pregnant. She's 3 months along. Does the child that is in gestation get to inherit? Well, the answer is it depends, because the answer to every legal question is it depends. But what it depends on is whether the child survives outside or after being born by 120 hours. So theoretically, the child, if everything goes well, once it's born, it's going to inherit from the grandfather. Now, granted, they won't be able to access the money until much later in life, but still they do get to inherit as a child. Hypothetical number two. What if, let's say I am adopting a child, and in my will I say I give my entire estate to my children. I have a daughter, and then we have an adopted child. It's going to be Billy, and we're in the process of adopting Billy when I die. Does Billy get to inherit anything? On the one hand, he's not fully adopted, but on the other hand, the process has started. And the statutes, the legislature has decided that once you've started the process of adoption, then you do get to inherit as if you were adopted. Notably, this does not count for, adoption is different than foster children. Foster children are not considered children of the foster parent for purpose of intestate succession. Third situation, surrogacy. Let's say a husband and wife, they can't have the kid themselves, they get an egg, fertilize the egg, implant it in a surrogate mother. The surrogate mother gives birth to the child. Does the child get to inherit from the surrogate mother when the surrogate mother dies? The answer is no. There is no parent-child relationship between the surrogate mother and the child. This will also be handled contractually as well, but under the law, a surrogate mother is not a mother of the child, and the child is not the child of the surrogate mother. Hypothetical number four. Let's say I give my entire estate to my son Billy, and in my will, that's what I say. I give everything to Billy, and then My wife and I decide we're going to adopt another person, another child. Say the child is a 12-year-old named Susan. I don't update my will and then I die. So my will only says I give my entire estate to Billy. Does Susan get to inherit anything? The answer is, it depends. As long as I don't have a provision in my will that says I give it to Billy and exclude anyone that I may any biological children in the future, or any child that I adopt in the future, I exclude them. As long as they don't say that, the courts will actually give Susan an equitable share of the entire estate that goes to Billy. So they'll probably split it 50-50. So as you can see, there's a lot of little gray areas that many of the laws have addressed, and what we haven't addressed in the law has been addressed in case law. Why does it matter? Well, the obvious one is for intestate succession. Intestate succession, as you recall, is when someone dies without a will. Then we go to the statutes and say, what do the statutory will says? It goes to the spouse, then goes to the kids. So if there's no spouse, then it's going to go to the children. And the children, we're going to have to figure out who is the child to figure out who's going to inherit. We'll also have to do this for wills. This is the second reason. Wills often say, I give to my children, or they omit or include certain children. Someone might have a claim under a will that's not listed in a will. So we have to figure out who the children are before we can finish probating a will. The final reason that we need to find out who is legally a child is for exempt property and family allowances. There is certain property, we talked about this in another video that happened a couple weeks ago, but there's certain property that is exempt from creditors' claims, such as the homestead, an automobile, certain personal effects up to $15,000, etc. Children can often receive this and not have it go to creditors' claims. There's also a family allowance that if you're a child and you are dependent upon or should be dependent upon the decedent, then you can receive an allowance of approximately $2,300 per month for 12 or 18 months or more, depending on the court. So as you can see, it's very important we actually figure out who is a child when we start a probate. So that's my take on children and inheriting in probate. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. We do a new video every other week. This is the last of a 10 video probate series that we're doing, but we will certainly have more videos on probate in the future. If you have any questions, leave them in the comments below or just send me an email. Happy to get back to you. Otherwise, until next time, this is Gregory Singleton from Signature Law.